Thank you for joining us. This is the first of what we expect to be several panels concerning President Trump's executive orders that have wreaked havoc in people's lives and are wreaking havoc to the legal system, raising profound questions about separation of powers, especially presidential authority, and have some scholars declaring we are facing or are on the brink of a constitutional crisis. On his first day in office, President Trump signed Executive Order 14160. The order was supposed to come into effect in 9 days, February 19th. I'll let our scholars here describe the order and what it purports to limit in terms of citizenship. But needless to say, the response to the order has been loud, swift, and widespread, with numerous courts addressing legal challenges to the order. Last Thursday, Federal District Judge John Kaufnauer in the state of Washington issued a nationwide preliminary injunction preventing the order from going into effect, and there have been a couple more courts that have issued similarly. In his ruling, Judge Kaufnauer stated, "There are moments in the world's history when people look back and ask, where were the lawyers? Where were the judges? In these moments, the rule of law becomes especially vulnerable. I refuse to let that beacon go dark today." Today we have three remarkable scholars, your professors, who teach and write on subjects that are at the core of the 14th Amendment, this order, and this legal dispute. Cassandra Burke-Robertson, Jonathan Adler, and Atiba Ellis, who will address this issue. And then we want to hear from you. We want to hear your questions and thoughts about the order and what it means for our legal system, our country, and our society. And I'm now going to turn it over to Professor Adler.
All right. Thank you, Ali. I'm going to start a little bit just kind of to set the stage on what was done in the executive order, which I believe there are copies that are being passed around. So first, I think it's just useful to understand what an executive order is. Some of you who've had me in class know this is a hobby horse of mine. Because media coverage of this and popular discussions of what an executive order is and is not gets this wrong routinely. Executive orders are official documents typically numbered and published in the Federal Register through which the President of the United States manages the operations of the federal government. That is the official definition from the Department of Justice. They are, in effect, the President's instruction to the rest of the executive branch about how the president expects the executive branch to fulfill its functions. That is why they are issued by a president. That's why one president can rip up the ones from his or her predecessor and can issue his or her own. Right? They're basically saying to their underlings, to those that work for them, both political appointees and career appointees, here's what I want you to do. This also means that usually you can't sue over an executive order. Professor Robertson will explain a little bit why that's perhaps different here, but as a general matter, the executive order is an instruction to people that run agencies, run things in the government to do stuff, and until they do stuff pursuant to that order, there's nothing to sue over. There's no injury for Article 3 purposes, nothing is ripe, nothing has happened. Executive orders have no legal effect unless they are adopted pursuant to congressional authorization. So, for example, under various emergency statutes, some of which President Trump has invoked, Congress has said if the president by executive order declares an emergency, then the following powers get authorized or the following actions can be taken. But otherwise, an executive order by itself does not yet have a legal effect, but it may tell people in the federal government to do things. The executive order here, and I probably should have done these in opposite direction. This is just the operative paragraph from it, but you have the full thing, is instructing agencies of the federal government, such as the Department of State, for example, which issues passports, those parts of the executive branch that have responsibilities that relate to identifying who is a citizen and then providing services or documents to people that satisfy that definition, to beginning, and I think it's February 19th, begin applying a different definition of who qualifies as a citizen than has been in place for quite some time, for many decades, I guess, over a century. And that definition is dependent upon whether or not only was that individual born within the United States, but also that at least one of that person's parents was either a citizen or a lawful permanent resident. So someone residing here and who is not a citizen, but residing and having the right to remain and intent to remain. Again, that's a dramatic change. And from a legal standpoint, it's important to understand this is the instruction to, say, the Department of State. If someone can't show you that they satisfy those criteria, then you don't issue them a passport. When that passport's not issued, that action or failure to act might be legal or illegal. But the instruction itself is not. One other wrinkle on that for those of you that have taken administrative law, or perhaps some of you that are in leg reg, even under the Administrative Procedure Act, the president is not an agency. So the default ways of suing the federal government, suing an agency, don't apply to the president, because the president is not an agency. But the Department of State, entities within the Department of State, and so on are, and so they can be sued more directly. Last thing I'll just say about the executive order, and we'll get into the detail and theory of this in a bit, is the executive order is based upon a theory of the 14th Amendment, and we'll spend a bunch of time talking about this, but here are the relevant portions. The first sentence of Section 1 of the 14th Amendment: all persons born or naturalized in the United States and subject to the jurisdiction thereof are citizens of the United States and the state wherein they reside. The theory behind this executive order is that the traditional understanding of the phrase "and subject to the jurisdiction thereof" is unduly expansive, that it is broader than or the definition that has been adopted by the federal government and enforced for all of our lifetimes is unduly broad, and that the president, pursuant to the president's obligation to follow the Constitution as the president understands it, is seeking to adopt and enforce and implement the president's understanding of a narrower conception of what that phrase "and subject to the jurisdiction thereof" means. So I will pause there in terms of what technically has happened. I think Professor Robertson is going to talk a bit about the litigation, and then Professor Ellis and I are going to talk a bit more about the 14th Amendment. So.
Thank you. So how the executive order got challenged. As Professor Adler said, usually somebody needs to be harmed. There needs to be actual action taken against them before they can challenge certainly an executive order. So part of the government's argument was this case wasn't right yet. Nobody has been harmed by this executive order. The three courts so far that have looked at this have found very easily that there is immediate harm. One of the most obvious forms of immediate harm is that if somebody who believed that they were a citizen or that their baby was a citizen, that citizen would not have to live in fear of deportation. So suggesting that they are not in fact a citizen puts an immediate fear of deportation into that person, or that person is a newborn baby, certainly into their parents. There's other federal statutes that come into play very early on as well, including children's health insurance programs, some of the benefits of which are limited to citizens, as well as the supplemental nutrition program, SNAP benefits for babies. So there was some immediate harm here. Then the next question is, well, how does it get challenged? And you've seen two procedural vehicles already, and I think you'll continue to see more. So Judge Kleinauer was the first one to rule. He initially enforcing the order. Temporary restraining orders, by their nature, are intended to be temporary, usually just 2 weeks. So he then held a hearing on a preliminary injunction. The preliminary injunction, if granted, would stay enforcement of the executive action until the case could be fully developed. Before Judge Kuckner could actually rule on that, Judge Boardman in Maryland ruled and issued a preliminary injunction. So Judge Boardman in Maryland and Judge Koynar, I'm not quite sure how to say his name, in Washington, both have now issued preliminary injunctions that apply nationwide, which kind of makes for an interesting situation when and if the government will appeal those preliminary injunctions. There's the possibility that there could be conflicting rulings on those injunctions, but they do now exist. And then just today, Judge LaPlante in New Hampshire has ruled as well. He also issued a preliminary injunction. I haven't seen the full ruling, but from the what was said at the hearing, it sounds as if his is not intended to be nationwide, but to apply in New Hampshire, in the area over which his court has jurisdiction. So preliminary injunctions are not super easy to get, but they are available when certain requirements are satisfied. So a preliminary injunction would stop the government from being able to enforce this executive order until the cases can be fully litigated. Person seeking a preliminary injunction has to show 4 elements. The first one is likelihood of success on the merits, that they are likely to win if this case goes to trial. The second element is irreparable harm is likely to occur absent preliminary relief. The idea is we need to stop this from happening now. If we wait until we fully litigate it, it is going to cause some irreparable harm. And then the third and the fourth elements actually come together when litigating against the government. But you would look at, does the balance of equities tip in the movement's favor? Does it appear more equitable to grant the injunction versus not? And then also, would the injunction be in the public interest? And all the courts to look at this have said, this is a blatantly unconstitutional executive order. And there is no public interest in not enjoining unconstitutional action. That the public interest says, we need to stop this unconstitutional action from happening upfront before the case can be fully litigated. So we have the 3 rulings. Preliminary injunctions can be appealed. And the government has shown an interest in appealing the injunctions. So I think we will see this go to the various circuit courts. I think the courts have so far been absolutely unanimous that this is not just unconstitutional, but blatantly unconstitutional. So we may not have any disagreements at the circuit level. It's interesting that of the 3 judges who have ruled so far, one is a Biden appointee, but one is a Reagan appointee, and the third was appointed by G.W. Bush. So you have judges appointed by both political parties who found this very an easy case for unconstitutionality. So if there is no disagreement among the circuits, that might be where the case ends. If there is a conflicting ruling among the circuits, I think the Supreme Court would want to step in very quickly to deal with any conflict that might arise. And I'll turn it over.
So I come at this as someone who is very interested in thinking about the thing I primarily write about, even though some of you know me from property class, but we'll get to you all in a second. But part of it is thinking about democracy. I write about voting rights and election law primarily, but there is this sort of question of below all of that, which is about what does American democracy mean? And so I come at it from that sort of question. And in thinking about this, I think about the social order that Section 1 of the 14th Amendment established in 1870. So I want to talk for just a few minutes about what that order was about and what order it was replacing, and sort of looking from there to what I think of as the Civil Rights Project in the United States, which, put very simply, take civil rights if you want more details on it, this fall, maybe. The sort of project of, in essence, making all people equal, but even though that sentence, even put simply, has lots of complications to it, and I suspect that I will offer a perspective, Professor Adler will offer a perspective on this. There is always interpretation to these doctrines and amendments, and in this day and age, one of the things that is sort of de rigueur here in law schools, but I think the world is shocked to realize that this is always a project of interpretation, right? This is always a project that is developing and is understanding. So I bring my understanding to you for a few minutes. And that is this, and those of you who are in my property class know that we read Dred Scott versus Sanford back when. If you haven't read Dred Scott, I think every law student should at some point in some course. But it is sort of the emblematic case about slavery and its meaning in relation to the Constitution, right? Scholars have called it the sort of ultimate personification of constitutional evil. Put very, very simply, the idea here is that Mr. Scott and the Scott family sued for their freedom when they moved from a slave state to a free state, and ultimately the Supreme Court of the United States, in rejecting their suit, defined them as people of African descent who did not have the constitutional capacity to bear rights, right? They had no rights under the law. And this, as I have argued in other places, sort of makes explicit what at least one reading of the Constitution and our constitutional history might offer in terms of establishing a sort of tiered personhood in the society of the United States prior to the Civil War. Now, I've yada 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 through a big chunk of American history, but we promised to keep our remarks short in order to open up conversation. So suffice it to say that that battle literally happened over the Civil War, and after it, during the Reconstructionist era, right, from the ending of the war in 1865, we had constitutional amendments passed to defeat the formal establishment of slavery as an economic institution, even though the state, in essence, retained certain rights to force labor. But then there was an unsettled concern, right? Ultimately, the concern was people of African descent who were made free because of this 13th Amendment, were they nonetheless citizens or not? And so there was a great deal of debate in the Reconstruction era over that question, and one of the first answers came from Congress in the Civil Rights Act of 1866, whose first sentence says, "All persons born in the United States and not subject to any foreign power," sound familiar, "are hereby declared to be citizens of the United States, and such citizens of every race and color without regard to any previous condition of slavery or involuntary servitude," skipping a little language here, "shall have the same right in every state and territory to make and enforce contracts," etc. And so the Civil Rights Act of 1866 is one of the places of the origin of what I've referred to as the sort of Civil Rights Project, right? This is a project about liberation and equalities to a certain degree by ensuring that people had the formal rights of citizenship to be defined. Now, of course, what the content of citizenship is a matter of debate that is tangential to our conversation here, but it is part of this project. And so there was this effort, in essence, to make black citizenship, if you will, certain to a certain degree. Of course, there are existential gaps about this, and I think Professor Adler will address some of those gaps. But for my purposes, this is one of the things. Intertwined with this is the citizenship of immigrants, including immigrants from China at the time and Native American persons here in the United States who were, and at the time were continued to be treated as not subjects of the United States. Native tribes are treated as sovereignties and therefore separate and apart. But this debate, out of this debate, in part came this language from Section 1 of the 14th Amendment to establish a national definition of citizenship. I also want to mention that in the debates, and we can kind of talk about the details in the Q&A, but it's worth noting the case of Wong Kim Ark that was decided in 1898, which directly addresses birthright citizenship issues. Mr. Ark was born and lived in California, the child of immigrants from China. He left on a trip and then returned to the United States, left on a trip to China, sorry. He was denied entry on the basis that he was not a citizen and thus excludable under the Exclusion Acts that had been passed as part of this debate over whether immigrants had citizenship status or rights at all and the extent to which they were removable and deportable. The government, in essence, argued that this man was not a citizen. The U.S. Supreme Court at the time rejected the government's argument, and the court, in essence, said, this clause means what it says. He was born here in the United States and therefore is a United States citizen. Derek Bell has pointed out that, and other scholars have pointed out, that this definition, if read the other way, would not only have excluded people of Chinese descent, but people of European descent who would have fallen under the same definition. And so Wong Kim Ark represents sort of this conventional understanding of the Birthright Citizenship Clause and has been here since 1898. So between these things we can tag together, there is this understanding of what birthright citizenship means. My final comment here is to say that I read this as a thread in the sort of fabric that ties us all together as Americans, as citizens, and it relates us within a simple and settled definition, right? The judge, when hearing the case, in essence, if you read his order, he basically all but laughs the case out of the courtroom as sort of the easiest definition of an unconstitutional order that he has seen in his 30 years plus on the bench. That says to me that this is well settled and meaningful. And that says to me as well that in an era where I see a lot of these threads being pulled on in terms of the equality and status of all of us in relation to each other, this to me is a particular thread that strikes me as fragile, and it is admittedly a political flashpoint, whether you agree with us or not. I think it tags onto a fundamental definition, and by pulling it, we endanger ourselves to the sort of what I worry about in terms of defaulting to grasping for definitions of legal personhood, of tiered personhood, that echo back to the era of Dred Scott. And I yield to Professor Adler.
All righty. So let me say just a couple more thoughts just about how to think a little bit about this history and the meaning of the amendment. And I think Professor Ellis put a lot of very important stuff on the table. This first sentence of Section 1 is universally understood to have been written with the intent of and in language that does overturn the portion of Dred Scott that held that individuals of African descent could not be citizens. As many people may know or may not know, generally been argued by many folks, including the Dred Scott dissenters, including President Lincoln, that Dred Scott was simply wrong on that point, not only in its failure to recognize what had been the practice in most states with regard to citizenship, but also failure to recognize the way the Constitution was ratified, in which individuals of African descent participated as part of the ratifying conventions, as part of the we the people that actually gave the Constitution its power in the first place. And so therefore, Dred Scott's conclusion, or Justice Taney's conclusion that such individuals could not be citizens was contradicted by the very source of the Constitution's own initial authority. The question that kind of we're dealing with now, or courts are dealing with now, is, okay, Section 1 clearly was meant to overturn Dred Scott. It was meant to ensure that all people born in the United States, whether in conditions of bondage or otherwise, would be recognized as citizens. And that would include those who were born to people who entered the country illegally. So as you may know, in 1808, at the first opportunity Congress banned the international slave trade, banned the importation of slaves. That did not end the trafficking of human beings, and the illegal slave trade continued. If one were to hold the position that a child born in the United States could not be a citizen because their parent was not lawfully here, one would then have a question about what do you do about children born to slaves who had been illegally imported, who were not legally in the country. And it was clearly understood that this language granted citizenship to such citizens, to such people, as it did to all those who were formerly enslaved, and to all without regard to race. And this was not kind of a niche concern. Abraham Lincoln signed the death warrant of an individual, a fairly notorious individual who trafficked in human slaves while he was president. Similarly, it was understood that this language would apply in a slightly modified form the traditional British notion of jus soli, which is that one's citizenship is defined by a territory where one is born, as opposed to by the blood of one's family. Most of Europe and Roman law had adopted the notion that one's citizenship is, in effect, hereditary based on one's blood. And there are still many countries that adopt this view in one form or another. The common law view was rather that it was based on territory, jus soli, where one was born, with the one twist in the United States that it wasn't the English notion that being born in a territory meant you were the subject of the sovereign of that territory, but rather being born in that territory meant you were a citizen of the nation of that territory, because obviously we had rejected the notion of a monarch or a king. And there are quite a few 19th century cases, one particularly famous one from New York called Lynch, that involved the children of sojourners, involved the children of people who were temporarily in the country, and whether or not the jus soli notion applied to them. And the dominant authorities said certainly they did. And so one goes through this history, one goes through this language, one notes that this language is even broader than the language that Professor Ellis quoted from the Civil Rights Act of 1866. My own view is it's particularly hard to argue that the original public meaning of Section 1 of the 14th Amendment allows for the Trump executive order. That is to say, the Trump executive order is contrary to the original public meaning of Section 1 of the 14th Amendment. And that's even setting aside the question of whether or not this is something the president could do unilaterally as opposed to something that Congress could do. Because I also have up on that slide Section 5 of the 14th Amendment, which gives to Congress the authority to define and enforce, or at least to enforce by appropriate legislation, the provisions of the 14th Amendment. And those of you who have taken constitutional law know that what it means to enforce the 14th Amendment as opposed to do something else is something that has been consistently litigated. So I think that there's a pretty clear original public meaning argument there. I want to complicate this for us a little bit so that we understand some of the moves that we're going to see in the debate and are seeing in the debate about this executive order. One of them is to say this language was adopted where, at least at the federal level, we did not have modern immigration laws. We had naturalization laws, but we did not have laws about entering. If you could get here, you could enter. They came shortly thereafter, right? Very soon after adoption of the ratification of the 14th Amendment, the Chinese Exclusion Acts were adopted. Other immigration laws were adopted to bar entry and to bar citizenship to people largely based on race or national origin, but they were later. And so there's an argument being made that, well, this was all based upon the idea that anyone could choose to come, and the policy of the nation was we wanted people to come, and if they had children while they were here, well, their children could be citizens. And so the argument is, well, then maybe that doesn't apply in a world in which the United States and other nations as well are much more aggressive about policing their own borders and deciding not merely who's a citizen, but who can enter. It's a serious argument, I think. Again, I think if one looks at the materials and the debate around adoption of the 14th Amendment, people were aware of these concerns. There were debates about the 14th Amendment, about whether or not this would mean the children of people from China or gypsies and the like would be, and other groups that were discriminated against at the time would in fact be eligible for citizenship. And the supporters in Congress said yes, they would. Right, Wong Kim Ark, that decision clearly consistent with what the authors and supporters of the 14th Amendment said during those debates. But it is worth noting that the context in which we think about citizenship and entry are different. Another thing we might raise the question about is I keep saying the original public meaning of this language. And there's certainly somewhere between 4 and 6 justices of the Supreme Court who claim to follow the original public meaning of the Constitution in their decisions. But that's not the universally accepted way of interpreting the Constitution. It's not the way the Constitution has always been interpreted by the Supreme Court. It's not the way that all law professors encourage it to be interpreted. It's not the way all judges think it should be interpreted. And if one is going to depart from the original public meaning, then one has to think about what other things should we be consulting. So there's a lot of late 19th century scholarship that coincides with the fall and repudiation of Reconstruction that adopts a much stingier view of Section 1 of the 14th Amendment. Now, this view was not adopted into law in terms of citizenship, but you can find prominent law review articles by prominent academics in the late 19th century, prominent legal theory thinkers saying that this language does not apply to the children of the temporary visitor or the child of someone who entered unlawfully. One might also think that if the language and understanding of the Constitution should be reflective of political changes, that political moments like the New Deal, like the Great Society, perhaps should change the way we understand and apply that language. Well, that doesn't only work in one direction. And if immigration is a different sort of political issue today than it was historically, well, does that mean that the political process, again, whether that's the president alone or Congress, gets to say that subject to the jurisdiction means something different than it has historically? Historically, it meant diplomats are excluded, foreign armies are excluded. Native Americans, when tribes were treated as sovereigns with which the United States entered into treaties, as opposed to quasi-sovereigns that have reservations. That's what we generally understood subject to the jurisdiction excluded. But could Congress say subject to the jurisdiction requires having been voluntarily allowed in, i.e. not be someone who's not subject to being deported? Under original public meaning, I think not. But if one has a different view of constitutional interpretation, that is a question one might have to confront should Congress enact legislation to that effect. And then that would also raise the question, again, those of you who've taken constitutional law may have thought about, how broad is Congress's power under Section 5 of the 14th Amendment? Is it as broad as the Warren Court thought in cases like Katzenbach versus Morgan, where Congress could effectively redefine the terms of Section 1? Or is it narrow, like the Supreme Court said in City of Bernie versus Flores, and is purely an enforcement power, not a power to actually change the meaning? Right? Again, that bears on how we think about these cases here. The last thing, just to be unduly provocative, Professor Ellis told us a lot about Dred Scott, and as I mentioned, President Lincoln thought Dred Scott was profoundly wrong and gave several speeches explaining why he continued to believe it was wrong even though it was the decision of the Supreme Court, and said somewhat provocatively that he did not believe he was obligated to follow the reasoning or the holding of Dred Scott insofar as he was not a party to the case, and he was not. The case was between Dred Scott and the Sanford family. It was a tort case. It was an unlawful imprisonment case. Lincoln said, I don't have to follow the holding that people of African descent are not citizens. And so he ordered his State Department to issue passports to individuals without regard to their race, even though that was in direct contravention to the constitutional holding of Dred Scott. And we generally, I think, say, yay, Lincoln, that was right. But that was going against what the Supreme Court had held was the meaning of the Constitution. Now, Lincoln also said, and this is an important caveat, that should there be a court judgment to which he or the federal government were a party, ordering them to do something different, they would do it. In this particular case, there wouldn't be, because you generally can't sue the federal government for giving somebody else a passport. So we have something very different here in that, as Professor Robertson mentioned, people that are denied passports or whose children were denied passports who should be entitled to them can sue, whereas people that didn't like what Lincoln did couldn't sue. But the idea that on issues of particular salience that a president might say, I'm going to follow my understanding of the Constitution until the courts tell me otherwise, isn't new, and is one that we've even seen with in relation to our precise subject. So I've gone on too long. I will stop there. And Professor Robertson, I'm going to let you run the show now.
Right. Well, let me actually follow up on one quick point from Professor Adler, and then we'll open it for questions. Because I think that it gets to the heart of what the government is arguing here and what the Supreme Court has already held in Wong Kim Ark. And that is, to what extent does kind of a violation of a law of the United States create room here, right? So in particular, if Congress has not authorized somebody to immigrate into the United States, does that or should that affect the citizenship status of the babies who are born? And that, I think, the Supreme Court actually did think about in Wong Kim Ark, because the case arose during the period of the Chinese Exclusion Act. And so Congress had said people of Asian descent are not eligible for citizenship. Congress had actually acted. And so the Supreme Court, in concluding that Wong Kim Ark was in fact a natural-born citizen by virtue of his birth in the United States, grappled with the idea of, does it matter that Congress has said that somebody of Asian descent cannot be a citizen? And the court said no, because the Constitution is the supreme law of the land, and the Constitution covers birthright citizenship. So it's interesting to me that the government here is trying to base the same kind of argument by saying Congress hasn't authorized this, therefore citizenship should not be granted. And that is why three courts have held that very clearly Wong Kim Ark controls and provides for citizenship. The court also made a very strong statement in another case around the same time. There was a case called Kwok John Fat versus White, where the question was actually a fact question. It was after Wong Kim Ark, and the United States was trying to exclude somebody of Asian descent. His argument was, I was actually born in the United States, I'm a citizen. And the United States' position was he was born in China. He's not a citizen and cannot become a citizen given the Chinese Exclusion Act. One of the things the court had to grapple with is, how do we litigate this? Do we require full due process in protecting the right to litigate the question? And the Supreme Court, for the first of many times, points out that citizenship is not just a fundamental right, but possibly the most fundamental right that somebody in our political system can hold. And the court says that it's better that there should be many people who are unlawfully present in the United States to be allowed to remain, if that means that not a single citizen is deprived of their constitutional right to be in the United States. And so this is kind of an argument that goes back to the Blackstone days of, it's better to improperly acquit 100 men rather than have one wrongfully imprisoned. The court is taking that framework and applying it to the immigration stage, saying citizenship is so important that we will tolerate some level of non-compliance with immigration law in order to ensure that no citizen loses their rights. So I will end it there and see if we have questions in the audience. Questions?
My question is related to the international affairs for the executive order. I read recently the executive order on the International Criminal ICC. And my question is, what are the limits of an executive order when it comes to the international matters? Because there was in a paragraph in the executive order suspension of the entry for the official or employee or agent of the court, as well as their family members. What they were American citizens. And additionally, how could we establish a jurisdiction?
I'll say some general points. I mean, first of all, under international law generally, the assumption within the United States is that international law is only binding insofar as it has become part of the supreme law of the land by ratification of a treaty by Congress, and that otherwise it is only binding insofar as Congress has chosen to make it binding. So that means there are lots of things that the United States participates in and cooperates with that are, as a legal matter, not binding in the United States. Second thing to note is that when it comes to domestic matters, we generally assume that the executive branch only has that authority that has been given to it by Congress. It is the power to faithfully execute the laws, but it's Congress that enacts the laws. And so we get debates about delegation and non-delegation and so on. But the idea being is that domestically, when the government is in effect acting internally, it only has those powers that were given to it. That is not always the assumption about power that is directed externally. So a lot of the doctrines that constrain or limit or narrowly construe power that's directed internally don't apply with the same force externally. So as a general matter, the executive branch on matters of trade, immigration, diplomacy, national security, externally directed national security, have far more leeway than, as a starting point, than internally. So instructions to the executive branch internally to do a particular thing directed externally or directed towards foreign entities or foreign institutions is more likely to have more direct force because it's not dependent upon, or not as dependent upon being able to rest on something that Congress has enacted. Now in this particular case, I'm not familiar with the details, but it's my understanding, and I'd be curious if anyone disagrees, but if someone is a citizen, they could not be denied entry. If they are a non-citizen, then there are all sorts of bases upon which they might be able to be denied entry temporarily. But if they're a citizen, and this has been true, right, in lots of contexts, right? We've had situations, far more extreme situations, where individuals who were citizens took up arms against the United States and could not be treated as foreign nationals for purposes of the law of war once they were detained. They actually had to be treated as U.S. citizens. There are some cases we cover in constitutional law that deal with the results of that. So if there were citizens of the U.S., I don't think they could be excluded.
This is really informative. Thank you. My question is sort of the implications of the executive branch's interpretation of the 14th Amendment and what that might mean on the second half of the sentence that's on the slide, specifically "and of the state wherein they reside," because I'm wondering what the implications might be on like births and territories, right? So we think about like people who are born in Puerto Rico or President Trump tried to make the claim that the United States is going to take over Gaza, and like, what about people who are born there? Like, I'm curious to kind of understand a little bit what the implications of their very narrow interpretation on birthright citizenship would have from a territorial context.
So the government's position pretty consistently throughout history has been that birth in a United States territory does not create citizenship under the 14th Amendment. There have been statutes passed to ensure that people born in the territories have citizenship. So Puerto Ricans are considered statutory citizens. There's a statute that makes them citizens. Every United States territory is currently covered by such a statute, except for American Samoa. So American Samoa, people born there are considered U.S. nationals, but not citizens. Nationals cannot be deported. They have the right to travel freely through the United States. They have the right to work in the United States, but have limited political rights, essentially.
And I'll just add, you've seen there's the phrase birthright citizenship and the phrase natural born citizen. So generally we understand the phrase natural born citizen to mean you are a citizen at the time of, as a consequence of your birth. That can either be because of birthright citizenship under Section 1 of the 14th Amendment, or because of statutes like the ones Professor Robertson mentioned that in effect naturalize you at the time of birth, despite not having been covered by Section 1 of the 14th Amendment. And so,
or being born outside the United States to a U.S. citizen.
right,
like
right, yes.
Ted Cruz.
Yes, right. So that's why Ted Cruz is a citizen. John McCain, who was born in the Panama Canal Zone,
Territory.
Right, it was territory. Note that according to the Trump administration, it's not clear that Kamala Harris would have been born a citizen under Section 1 of the 14th Amendment, and therefore might not have been eligible. I mean, there's this meta question about is the Trump administration's position this is what the 14th Amendment has always meant, or is this their position that this is how we are going to understand it and enforce it? If the Trump administration's position is this is what the 14th Amendment has always meant, we have this really big question is that there are lots of people that we've extended citizenship to who we shouldn't have, and lots of people who we don't know, and how are we going to put those records back together, right? Because like in a birth certificate, it will often say where you were born. It will sometimes say where your parents were born, but if this was always a view of the 14th Amendment, well then knowing where your parents were born doesn't solve the issue. And I guess, there are these other questions or Pandora's boxes that get opened up that get really messy.
And I just want to add a comment to all this, because both the sort of real-world examples that my colleagues have spoken to implicate directly the political system, right? And it kind of goes to the heart of why citizenship matters. It's important in the rights, because in another one of those Chinese exclusion era cases, Big Yo versus Hopkins, the court says, well, it speaks to the list of rights, but it starts with the right to vote. The right to vote is the most fundamental of rights. Read here that you get because you are a citizen, because it is preservative of all other rights, right? So, I mean, there is this sort of status structural thing here that is the implication of all these conversations. And it's one of these interesting places where when we talk about the margins of who gets to be in the political community, if you will, is where the pressure as to what this means is revealed, right? So, but of course, the implication of this, at least as I read it, is if you get pushed to the margins, if you get pushed to the edges, then you become more vulnerable in relation to the larger political community. And as one of the long-standing questions of constitutional law is, to what extent are we obligated to protect those minorities, however we read that minority to mean, I would argue. But like a good professor, I just love throwing out big questions and then moving on to the next hand.
last part of the executive order says it wouldn't take place, I believe it's to people born, there's 30 days, and then it would take place to people that are then born here, is that correct?
February 19th.
Yes, February 19th.
So would that, like the Pandora's box you were talking about, is it possible that it would be retroactive?
Yes. Yes, it's very weird. And probably one of the ways in which the executive order is overstepping, because the executive order part A of it, or part 1 of it, is trying to state that this is how the law currently is, right? It is just making a statement, I think falsely, that currently the law does not provide birthright citizenship in these situations. And then section 2 is the actual order for how we're going to administer the law. Well, we're not going to provide citizenship benefits or passports. And for that, it says we're only going to apply this to people born 30 days after the date of this order, so not retroactively, but it's still saying our position is, even retroactively, that other people are not citizens.
So
I just, like,
here's the way to understand this, right? So if we think that the 14th Amendment sets a broad set of parameters that the political branches then get to implement and effectuate, and part of doing that is filling in the details, then the idea that the details might be different at time period A as opposed to time period B makes some sense. The problem is that we've always understood that that's Congress's job, and even if one takes the really and so the debate is whether we take the narrow view of that, which the current Supreme Court seems to take about Congress's authority under Section 5 of the 14th Amendment, or the broader view that the court took in the 1970s. Either way, it's Congress's job. So there is a separate debate, which maybe this is just a prelude to whether Congress could do this. But Congress could say, we've understood subject to the jurisdiction to mean X. We now understand it to mean Y because we are defining our own jurisdiction in this way. The executive branch doesn't have that authority, which is why the executive branch saying this is the meaning of the Constitution and we are going to begin enforcing it this way at a particular point in time raises this very difficult question. Now, there are other doctrines, some of them in equity, that might prevent the federal government from ever applying any of this retroactively. And we've seen that come up in the DACA litigation. That came up. We've seen that come up in other contexts. The idea, in short, that insofar as the government treated you in a particular way, it has made assurances to you that you could reasonably rely upon. The government can't pull the rug out from under you. But that still gives you a slightly different status than saying what the government did was lawful all along. Yeah. And but as an executive order, they kind of fudge this and just kind of raise these questions and then just say, oh, well, 30 days, we'll just change who we get passports to.
Yeah. I mean, I think that you would see a situation where a state might try to prosecute somebody for voting when they're 80 years old, they've been voting all their adult life, but their parents were undocumented, born in the United States. Like that, I could see that happening based on this.
And bear in mind that more and more states, including the state of Ohio, have changed their definition of voting to be restricted to citizens. Mm-hmm. Yes.
So what's the purpose of not taking any action against what is considered as unlawful or illegal executive order? Although you know it's going to have bad implications and there are people are going to be actually harmed, like it's foreseeable.
Well, in terms of why you can't sue against the executive order itself? Because it has no, so generally, and I'm going to oversimplify a little bit, we want two things in particular to be able to sue a governmental action. One, it has to be generally what we consider a final action. Usually a final agency action. The president's not an agency. That is one difficulty by itself. But we need a final action. We need whatever the government's doing to kind of reach an end point so we know what it is we're challenging. And that typically has to be something that in and of itself alters legal rights or responsibilities. So the president merely saying, our policy is the following people are not citizens, hasn't actually changed anyone's rights or responsibilities. It hasn't actually deprived anybody of anything. It's only when an action is taken upon that. The second thing is we generally need somebody who has been injured. We need someone to satisfy Article 3 of the Constitution, to have an injury in fact that is actual or imminent, concrete or particularized, fairly traceable to the governmental action and redressable. And so you need somebody to basically say, I'm the one that was actually hurt by this. And I can't go into court just saying, somebody in the government is doing something illegal. I need to say, someone in the government is doing something illegal that hurts me, so I have the right to invoke the jurisdiction of the federal court to hear my claim. In this case, as Professor Robertson mentioned, because it's on this 30-day timetable, we can identify people that are going to be affected in 30 days, which is why court cases have been filed. But that makes this a slightly unique executive order, where usually the executive orders just say, minions, go try and do the following things insofar as it's consistent with law, and then we have to wait for one of the minions to do something before somebody can sue.
Yeah, but here some of the plaintiffs are actually women who are women who are pregnant and their babies are due more than 30 days later. So there's an immediate question of, can that baby get a passport? Can that baby get children's health insurance, etc.?
The student, yeah.
What is the role of Congress in overseeing or limits executive orders?
I mean, executive orders generally can't contravene an act of Congress. One of the problems here is that most of the relevant statutes use the phrase subject to the jurisdiction of the United States and have not fully defined it. So the executive branch is trying to think, well, there's this phrase. It's in the Constitution. It's in the statutes. We're going to tell you that it means something different than you thought it meant. Congress could clearly enact a statute saying, no, we mean something else, but they haven't. There is other litigation on things like passports that has actually concluded that Congress's ability to regulate the issuance of passports is actually somewhat limited because of the foreign policy implications. I'm not sure if this affects this order, but it is worth being aware of.
In regards to what Congress can do to enforce the Section 1 of 14th Amendment, I guess, would it be that they can clarify it by making it broad or upholding how broad it is, or could they also make it narrower?
They could definitely make it broader, or equally as broad as what the Supreme Court has held in Wong Kim Ark. Yeah, Congress has the authority to say who can be a citizen. They don't have the authority to preclude, to withhold citizenship from somebody that the Constitution makes a citizen. So that's why we have different rules for the territories, although I've argued in writing that we shouldn't, that the territories are still a fundamental part of the United States. Won that one. But that's why Congress can say, by statute, we're going to say that people in Puerto Rico are citizens. They're allowed to do that. They could not say that, I believe, according to the Constitution, that somebody who is born to undocumented parents is not a citizen if born in the United States.
One thing we didn't cover is worth noting. The traditional understanding of subject to the jurisdiction has meant is someone obligated to follow the law. So the reason diplomats aren't subject to the jurisdiction of the United States is because they're not obligated to follow the law, right? That's why there are all these unpaid parking tickets in New York from UN representatives, because they don't pay them. Same thing in DC with embassy personnel. Foreign armies, not subject to the jurisdiction, right? If an army invades and we capture enemy invading army, we may subject them to military jurisdiction, but they're not subject to the general legal jurisdiction. They are not obligated to follow U.S. law. They may be obligated to follow the law of war or something else. The argument that some would make is that if someone has entered the United States unlawfully, they have not consented to or adopted any obligation to follow U.S. law because they entered unlawfully. Set aside people that entered lawfully but overstayed their visas, which is arguably a different case. The problem with that is, one, the subject of the jurisdiction is really about the child, not the person, not the parent. And jus soli is always understood when you are born in the territory, you are subject to the jurisdiction of that territory. You are born with the protection of an obligation to comply with the law of that territory, no matter who your parents were. Right? This is why, for example, it was understood that this would apply to the children of slaves who had been trafficked unlawfully in violation of the importation ban. The other thing that's difficult about that definition is that traditionally the way you deal with someone who is not subject to the jurisdiction, if you don't want them here, is you just make them leave. You don't prosecute them. And so it's hard to understand how Congress could declare people who are unlawfully present in the United States to not be subject to the jurisdiction of the United States, but still be subject to criminal prosecution for crimes they commit. Because insofar as we prosecute people who are not lawfully present, we are subjecting them to our jurisdiction, the way that phrase has always been understood. So, there's this theoretical possibility that Congress could try and redefine subject to the jurisdiction in a way to try and square that circle or conceptually handle that in a way that it hasn't been done before. But one of the reasons it's so hard to conceive of how that would work is because our federal government has always acted as if individuals in the United States who are not diplomats or families of diplomats and not foreign armies who commit crimes in the United States are subject to our jurisdiction. They can be arrested, they can be tried, they can be sent to jail, they can be executed. That's subject to the jurisdiction.
And the Supreme Court says that explicitly in Wong Kim Mark. They say every person born in the United States is subject to the jurisdiction thereof, unless they fall into one of the exceptions, like children of diplomats, or in that time, some of the tribes. And those narrow exceptions were really a matter of comedy. It was about not forcing United States citizenship on somebody who had a prior and kind of more important allegiance, whether that was recognizing tribal sovereignty or recognizing the sovereignty of the diplomatic representative from another country. It wasn't about the status of the person in the United States.
This changes my personal life history too, but that's okay. But it seems like, right, so in that paragraph where they are particularly mentioning the mother's presence and then the father's status is just kind of like an afterthought, and the father is not a citizen or lawful permanent resident, right? So it seems as if a mother who is here, let's say, on a student visa would be a good litigant for this sort, right? Like, I'm here legally right now with the expectation that my child who's being born is a citizen, I have a reason to be here, and yet this harm is being faced. They don't mention, this is what I wonder, what if a father is here on some sort of, whatever, any of these, visiting, tourist visa, student visa waiver program, they don't mention that, so.
Yeah, I think they're just looking at the mom because they're looking at the child's birth. So the mom would need to be here physically for the child to be born here.
That's common in immigration. That's common in immigration law. Some years in Congo, I know this last semester, we do a case where, by statute, there's weirdly different rules about citizenship depending on whether the parent, the mother or the father was a citizen, and the other parent was not a citizen. Even for children born outside of the country, what you have to do to get natural born citizenship depends on which one was the citizen. That's common in immigration law. The kind of overly simplistic, too cute explanation of why immigration law does that is because, as a biological matter, the mother has to be present at birth, and so that's you don't need to do other things to document that relationship, whereas you might have to do additional things to document the relationship with the father. Mm-hmm. So I think that's why the language is acted that way.
So then the follow-up to that is, ostensibly, let's say there is an unlawfully present mother and father, whatever, here, and then the child is born, they have to kind of out their unlawful status, right, in order to be able to sue on behalf of the child. They're just a foreign national at that point, and even if they're deported, they could sue the United States as a foreign national.
So I will say that the plaintiffs in the Maryland case, they were allowed to go forward under pseudonyms so that the government
Oh.
wouldn't know who they were.
Okay.
Yeah, and that's kind of an interesting civil procedure thing that it's pretty rare for people to be allowed to sue under a pseudonym. And usually, if they do, at least the defendant will know who the person really is. But the judge here ordered, allowed the plaintiffs to go forward under pseudonyms and told the government that she would not be sharing the names unless the government could show a documented need for those names as part of the litigation, which they have not done. Yeah, there's some nonprofit organizations, a lot of states, and the pregnant women.
Out of curiosity, the courts who granted the preliminary injunction, did they give any other basis? I mean, I read something where one of the judges says this is just blatantly unconstitutional.
Yep.
Other reasons you haven't mentioned?
The biggest reason was that Wong Kim Ark really just controls the case completely, and it's binding Supreme Court precedent. The government lawyers tried to say it was just dicta, because in Wong Kim Ark, the parents of the child were lawful permanent residents of the United States. And so the government tried to say, well, then it's just dicta because the court wasn't actually applying a situation where the parents were there without permission. And the judge does a really nice kind of discussion of the difference between dicta and holding, and points out that actually the broader meaning of the 14th Amendment was very critical to the holding of Wong Kim Ark, and that the status of the parents was not analytically meaningful. And then also cited a lot of cases saying essentially lower courts are also bound by Supreme Court dicta. If the dicta is analyzed and reasoned, then lower courts are still bound by it. So that was kind of an interesting approach. But yeah, the courts have really been focused on Wong Kim Ark and its controlling. They also do cite that originalism scholarship. The Seattle case goes back and looks at the debate over adopting the 14th Amendment and points out that critics of the 14th Amendment at the time were concerned, saying, well, wouldn't this just make every child of immigrants a citizen automatically, and we don't necessarily like that. And the court points out, they had that debate and they lost that debate with the ratification of the 14th Amendment.
There's one of the briefs spends a lot of time talking about how often it's mentioned that the parents in Wong Kim Ark were domiciled, but ignore the language that actually explains the basis for the holding. But that's and there's an old Joseph Story quote from, I guess it's his Conflict of Laws treatise, where he's talking about theories of citizenship generally and what the basis should be as opposed to what the law is in the United States, which also isn't very persuasive because, as important as Joseph's Story was as a constitutional thinker, he wasn't infallible, and given that he wasn't alive when the 14th Amendment was adopted, it's not clear why his scholarship would be very probative about what the 14th Amendment meant. And then there's one other source. But there's just not a lot there and it be in the briefing. And if you go beyond the briefing, the most powerful stuff there is this body of 19th century scholarship, much of which was, with the currents of the times, hostile to true or expansive understandings of the 14th Amendment. And there's dicta in the slaughterhouse cases from Justice Miller, who not only wrote Slaughterhouse, which most academics think is bad in of itself, but was himself an opponent of the 14th Amendment. So it's not clear why stray comments by him about the 14th Amendment are all that probative. But there is this 19th century scholarship that at some point there will be a brief laying out.
Exhausted your questions. Seems like this would be a good time to adjourn. So, thank you. you for participating. Thank my colleagues. We'll announce the next of these series of panels in due course.
Maybe we can rejoin for our contempt of court. Oh, yeah.
We have one for each Trump executive order this year. I thought it was good.
So Aaron, you just take me right.
One issue. Like Martin name and shut it down. Yeah, he said, much.
Thank you, professors.
Yeah, nice job. That was awesome. Thank you.
Hi, Professor. Good, how are you?
Bye.
Tudo bem?
The biggest problem with that is the incorporation prior. The incorporation prior requires. There's no question about it.
Você não viu? Eu quase. 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 Eu ia quebrar uma perna aqui. Ai, vai ficar gravado. Chatice, né? Nada, melhor pra fazer. Eu vou depois. Eu quase, eu virei meu pé aqui, ó. Ah, mãe, eu me equilibrei. Vai pra casa, meu filho, você dorme. Aí eu vou contar tudo. Isso é verdade. Tô com fome. Bye, thank you.
Thanks for coming.
That's assuming that.
illnesses. I mean, I'm saying there are other.
Means taking folks that will drive.
But $38 million deficit, and that's before.
They didn't understand that when they were doing the hire. I mean, I think the likelihood of that rider not being the next I think the response is to go back to the efficiency.
I mean, in particular, I saw top 50 affected. It's the biggest employer in Durham County, North Carolina. Suddenly, or nail in the foot of like 2, maybe 3 congressional districts, and multiply that by 50,
And the
Right.
and the overlap with the interesting because the list too though is the overlap with schools.
yeah,
So like UCSF, for example, right, has a hospital and that gets a lot of grants.
no, I was thinking specifically the 50 with big hospitals, that are big NIH recipients, precisely because they have huge university teaching hospitals, which also do all this research. Right? So, but still, I think you're right. The political fallout of this, left unabated, will be more than.
Question about the accommodations because the accommodation won't just be. Because the administration will want to be able to look through. Faculties haven't grown with administrators.
I mean, this has been a long-standing. People have been complaining about this for 20 years.
But now there's political.
And I mean, there's part of me that says, yes, if this misproperly defines the problem to be solved. Yeah. And I just but the problem with administrative work does not relate to research. I mean, we can talk about trimming fat and things and what a reasonable indirect cost rate is, but administrative bloat goes way beyond what the research budget, or specifically NIH research